letters to the contractors. However, we haven't noticed any financial problems on the contractors' side.
24年
Government bills. This Council resumes the second reading debate on the Companies Amendment No. 2 Bill 2024. Mr. Edmund Wong, Chairman of the Bills Committee on the bill, will first address the Council on the committee's report. Mr. Edmund Wong. President, I submit this report in my capacity as the Chairman of the Bills Committee on Companies Amendment No. 2 Bill 2024. The bill seeks to amend the Companies Ordinance and its subsidiary legislation to provide for a regime to enable companies incorporated outside Hong Kong, that is non-Hong Kong incorporated companies, to redomicile to Hong Kong and provide for related matters. And these related matters are technical amendments. This Bills Committee has held 4 meetings totaling 10 hours and received 5 written submissions from deputations. The Bills Committee is generally supportive of the bill. Members agree that the introduction of the redomiciliation regime will facilitate non-Hong Kong incorporated companies to change their domicile to Hong Kong. These companies will directly benefit from Hong Kong's robust market environment and highly transparent regulatory regime. They will also bring impetus to the local professional services and capital markets. The committee has conducted in-depth and comprehensive deliberations. Members have raised concerns and suggestions to the bill. A number of members have expressed grave concerns on whether an application for redomiciliation may be refused if the registrar is of the opinion that the intended redomiciled company is likely to endanger national security. Members are of the view that the administration should fully consider national security risks and the responsive measures when formulating the proposed regime. Having considered the members' views and having reviewed the relevant provisions, the administration will move amendments to make it certain that it is the registrar's duty to refuse the application if the registrar is of the opinion that the intended redomiciled company is likely to be used for an unlawful purpose or for a purpose contrary to public interest. Members also note that the registrar's administrative decision of refusing an application regardless of whether it is made on national security reasons is subject to judicial review. The bill proposes that within 120 days after the redomiciliation date, the redomiciled non-Hong Kong incorporated company must be deregistered in its place of incorporation. Expressing concern about the potential impact of the excessively long transitional period on the company's legal proceedings, members have suggested that the administration should, with reference to the relevant legislation of Singapore, adjust the time frame for the registration to 60 days to reduce potential legal risks. The administration has advised that the relevant provisions stipulates the effect of redomiciliation. In particular, it does not affect the company's contracts, legal obligations, etc., nor does it create a flaw in the legal proceedings to be initiated by or against the redomiciled company on ongoing ones. The proposed 120-day period is proposed on the basis of the stakeholders' views received during the public consultation. The redomiciliation regime will help attract overseas companies to set up presence in Hong Kong. Therefore, members have urged the administration to ramp up publicity following the regime's establishment. The administration has advised that it will proactively promote the regime to non-Hong Kong incorporated companies operating their business in Hong Kong through economic trade and trade offices, the Invest Hong Kong, as well as OASIS. Members have pointed out that the overall drafting approach is too cumbersome to achieve simplicity and readability. They've urged the administration to use concise and easily understandable terminology and drafting approach in drafting other bills in the future. Noting this view, the administration will actively respond to legal and drafting suggestions from members of the committee as well as the legal advisor. It will also move amendments to improve drafting so as to better reflect the legislative intent. Accepting the views from deputations, the administration has agreed to specify the deadline of the legal practitioner to issue the legal opinion of the origin of incorporation of the companies. The administration will move an amendment to specify this deadline as 35 days before the redomiciliation application date. The Bills Committee supports the administration's proposed amendments. President, I'd like to offer my views on the bill. With the OECD's BEPS 2.0 proposal and its full implementation, 140 tax jurisdictions, including Hong Kong, will be subject to a global minimum tax rate of 15% against multinational corporations. A lot of tax havens will be listed as entities by the EU as a uncooperative list, and these tax jurisdictions will no longer have any attractiveness as they are unable to offer ultra-low interest rates. Now, as for the Hong Kong enterprises which have set up offshore companies in these places, they have planned to redomicile the business to Hong Kong, and this regime will provide a gateway for them. Hong Kong is an international financial and trade center. Now, with the global minimum tax rate, there is now a standardized tax rate around the world, and we have great market efficiency as well as robust financial infrastructure, financial talents. Our legal system is well aligned with international laws. So many offshore companies registered outside Hong Kong will redomicile to Hong Kong. Many non-Hong Kong incorporated companies will also be incentivized to set up presence in Hong Kong as well. The object of this bill is to provide facilitation so that non-Hong Kong incorporation intending to redomicile to Hong Kong will no longer have to be wound up in its original domicile and establish a new company in Hong Kong, and that the legal entity and the status can be preserved. This facilitation will promote redomiciliation of non-Hong Kong incorporated companies to come to Hong Kong. They will also bring jobs as well as capital to Hong Kong. Apart from amending the company's ordinance, this bill also amends a number of ordinances such as a business registration ordinance, SFO, banking ordinance, so on and so forth. Altogether 39 of them. This is a rather complex amendment bill. After introduction of the redomiciliation regime, professionals will come in to provide help with the implementation process. That is why professionals sitting on the Bills Committee have carefully scrutinized the bill in the process to ensure smooth and effective implementation of the regime. President, the proposed redomiciliation regime will give effect to the objective of the bill so as to attract non-Hong Kong corporations to redomicile to Hong Kong. I believe that we should, on the whole, meet the three criteria. First, we should not impose unreasonable thresholds. We should provide facilitation to applicants. Now, the bill has incorporated stakeholders' views. For example, the registration in the place of domicile, the time frame will increase from 60 days originally proposed to 120 days, so as to reduce uncertainties. Now, I believe this is a major incentive for enterprises to decide whether to redomicile to Hong Kong. The second point is tax incentive. We need to offer incentives tax-wise. Like I said, after implementing BEPS 2.0 and the global minimum tax rate, many tax havens no longer enjoy the edge. And Hong Kong also abides by a simple and low tax regime. We will be enjoying this advantage. So I actually raised this concern at the Bills Committee meetings. That is about stamp duty on stock transfer. For companies incorporated in Hong Kong, the stamp duty will be charged for transfer of shares. According to the sector, this stamp duty arrangement is disincentive for Hong Kong companies, and that they would opt for overseas incorporation instead. Although the administration has emphasized that the redomiciliation does not involve the charging of stamp duty since no shares will be transferred, I must emphasize that for non-Hong Kong incorporated companies redomiciled in Hong Kong, they would need to abide by other applicable laws, including stamp duty. The government should further remove the hurdles to enhance attractiveness of the policy. The third criterion is this: we need to have policy certainty. The U.S. President Donald Trump imposed tariffs on different on countries around the world. In fact, our country just sealed a deal with the U.S. and issued a joint statement, and that the tariffs will be subject to a 90-day pause. The tariff rates will be substantially slashed. However, there is a lot of uncertainty in terms of the U.S. administration's tariff policy. On the contrary, we go by policy certainty. We have always been abiding by the zero tariff policy, so that's a stark contrast. I hope that with the passage of the bill, the administration will ramp up their efforts to promote Hong Kong's advantages, including the institutional advantages and the good prospects of Hong Kong through ETOs and Invest Hong Kong, so that many other non-Hong Kong incorporated companies will set a presence in Hong Kong and further consolidate our position as the international business hub. Now, I'm in the accounting profession, and the company I work for is also providing services for redomiciliation. At the Bills Committee, I offered my professional views about certain provisions. Now, one of the areas of concern is that a special resolution will have to be supported by at least 75% of eligible members of the company or shareholders before the redomiciliation can be approved. And I find that in terms of the definition of eligible members, there may be a discrepancy between different provisions. The administration has noted the discrepancy, and it has agreed to take on board the views of my sector and myself, and that an amendment will be moved to ensure that to clarify the definition of eligible members and the 75% vote. Now, I thank the administration for heeding the views of myself and the Bills Committee. Amendments will be moved to improve the bill so that the redomiciliation regime to be implemented will meet the needs of the sectors. It will also help enhance our competitiveness. I fully support the bill. President, I want to emphasize that this bill opens a door for overseas enterprises, but we're not keeping everything open. We need to do our gatekeeping properly. The amendment provides that if, in the opinion of the registrar, the company intended to be redomiciled to Hong Kong has done so for an unlawful purpose or for a purpose contrary to public interest, then the registrar must refuse this application. I strongly support this amendment, regardless of whether the refusal is made on the ground of national security or the applicant can file a judicial review on this decision. That shows that Hong Kong is a highly open economy. We welcome friends from around the world to set up business in Hong Kong. I so submit I support the government's bill and the amendments.
Dr. Starry Lee. President, I speak in support of the second reading of the Companies Amendment Number 2, Bill 2024. We're in a highly challenging global landscape. This bill is important for Hong Kong as an international financial center. As Mr. Edmund Wong just said, the global tax landscape has been upended in recent years. Now, with the OECD's effort, more than 140 jurisdictions across the board have adopted the global minimum corporate tax rate. Many offshore jurisdictions have also imposed the economic substance test on the businesses there, and that means higher compliance costs. Now, with the exception of open-ended funds and also limited partnership funds, Hong Kong has no effective mechanism for offshore companies to re-domicile to Hong Kong. That means for a non-Hong Kong company to move their domicile here, those companies have to first go into winding up before establishing a new presence in Hong Kong, or they have to go through a complicated court procedure to achieve the goal. And that means a complicated procedure and high costs. The companies involved won't be able to keep their legal identity, intellectual property, and also contractual relationships. For so long, we have been trying to attract overseas companies here. We wanted to bring them back here, and this has been an obstacle. With this redomiciliation mechanism, non-Hong Kong companies will have a straightforward way to move their domicile to Hong Kong. They will get to keep their legal identity. This regime brings many benefits to Hong Kong. One, stronger demand for our professional services. More companies coming here means for people like lawyers, corporate secretaries, and other professionals, the service demand will grow, and that will mean business. More business for these professionals. Redomiciled companies will also bring more business here, and that will mean more investments to Hong Kong. When those companies make more money, that means more tax revenue and more jobs. And that will strengthen our economy and make our economy more resilient. Hong Kong will also become a more attractive international business hub. There are non-Hong Kong corporations already active in Hong Kong. When they redomicile here, they will benefit from the high level of corporate governance here. Now we have the global minimum corporate tax rate. Here, Hong Kong has a simple and low tax rate. We have a highly efficient compliance landscape. So here, businesses will find a great choice to reduce their compliance cost. I support this bill, but I do have some thoughts to share. This morning, I have already said this. We are simply taking the first step with this bill. We still have to keep enhancing the regime. So let's bear in mind what we want to achieve. Do we simply want to attract the 15,000 businesses already with a presence here, or should we be more ambitious? We have many listed companies here. After all, we are an international financial center. But then, because of tax considerations, they set up many branches, arms in the British Virgin Islands. Now, there are hundreds of thousands of offshore companies held by entities in Hong Kong. So we should be more ambitious than aiming for just the 15,000 companies with a presence in Hong Kong. Let's be more ambitious. Getting more companies to redomicile here means more economic opportunities and more jobs in Hong Kong. And that means more profits tax and more salaries tax for Hong Kong. So I hope the government will work hard. Let's get more overseas companies and offshore companies held by individuals to come here. We are looking beyond just the registration numbers. Those companies coming here will get legal protection, and we're also aligning their businesses. We have the acting secretary here. Please get someone to reach out to our listed companies. Let's find out how many offshore companies their groups hold, and let's also find out about their family offices. To be fair, Invest Hong Kong has done much. Let's explore how we can bring those companies here. Let's find out where the hurdles are, and this will require more research, more work lies ahead. And let's find out the needs of each company. Now, one obstacle we have to face up to, and this is a key obstacle, and that's the stamp duty. A redomiciled company will be deemed as a company incorporated in Hong Kong, and that means stock transfers will be subject to the stamp duty. And that may be why some companies are hesitating. Some groups hold many BVI subsidiaries. When you apply the stamp duty to those subsidiaries, those groups will want to think twice. So we need creative thinking. I get it. The stamp duty is a key source of tax revenue for us, but we have to weigh the pros and cons. So let's review our laws on stamp duty. So let's review the stamp duty on the transfer of non-listed companies. And let's also look at the matter about stamp duty on REIT, or real estate investment trusts. With greater clarity over details, we will be in a better position to persuade more companies to redomicile to Hong Kong, and we won't be harming the tax base of Hong Kong. Now, within 120 days after an offshore company redomiciles in Hong Kong, this company will have parallel registrations, both in Hong Kong and the overseas domicile. And when there are stock dividends received by this company, so can we get our IRD to issue a tax resident certificate so that that company will enjoy a lower tax withholding level? We want to welcome companies who seek to redomicile here, but we also had to be strict as a gatekeeper. The bill empowers the Register of Companies to refuse a redomiciliation request if the registrar believes it's likely for the redomiciliated company to be used for a purpose that's against public interest or threatens under national security. I support this. We want to keep our country safe, but let's also keep our low tax regime and our efficient business environment. Putting in place this redomiciliation regime is a necessary step in response to the evolving landscape. Trump has thrown around the so-called reciprocal tariffs, so that is all the more reason we have to act, and we have to do something to strengthen our role as a hub of global business. So let's continue to work through our economic trade offices, our OASIS, and also other offices of the HKSAR overseas. Let's promote our new redomiciliation regime. We need policy breakthroughs, we need better tax arrangements, and let's expand the scope of our policies and get the gatekeeping right. The redomiciliation regime will achieve great things for Hong Kong. There will be huge benefits for Hong Kong, and that will also strengthen our role as an international business and financial hub. We can be not just a home for companies, but also a safe harbor for businesses. I support the bill. Ms. Carmen Khan. I speak in support of the company's Amendment Number 2, Bill 2024. This bill seeks to amend the company's ordinance, its subsidiary legislation, and other ordinances so that companies incorporated outside Hong Kong can transfer its domicile or their domicile to Hong Kong. The global landscape is volatile, and that's why this bill is so important. More than 140 jurisdictions have adopted BEPS 2.0. Large multinational groups are subject to a 15% global minimum corporate tax rate. And then the conventional tax havens have also imposed the economic substance test on their businesses, and that means higher operational and compliance costs. Those jurisdictions will lose their edge. Here, Hong Kong has a simple and low tax regime. We have an efficient environment. We have many listing options. We have our country's backing and global connectivity. Our edge will attract more companies here, and that will mean a greater need for Hong Kong's professional services and also more investment and more jobs. Let's look at other jurisdictions. Australia, 1968, New Zealand, 1993, Singapore, 2017. Those places in all those years have put in place their inward redomiciliation regimes. So in the 2023 to 24 budget, when this redomiciliation regime was first proposed, I gave my full support. We're now in the 2025-26 financial year with a new budget. We cannot fall behind in this global race, so putting in place this regime is a race against time. The sooner we put it in place, the better. I want to share my thoughts on 3 points for this regime so that we can maximize the benefit of this regime. 1. Let's not overlook the huge opportunities for mainland businesses. The regime under this bill is about inward redomiciliation. A non-Hong Kong company can move its domicile to Hong Kong as long as their own domicile does not oppose it. As at the middle of last year, we had 2,500 listed companies, 70% of them, meaning 1,700 or so listed companies, were incorporated in places like Bermuda or Cayman Islands. During this bill's deliberations, the administration said they would mainly target those companies for this bill. But I think, as we pursue this regime, let us not overlook mainland companies. Recent figures shows, let's look at the HSI constituency companies. 83 companies there are, and 44 red chip stocks or other mainland companies listed in Hong Kong, and they make up 51% among the 83 companies. And these mainland companies make up $31 trillion, and that's over 80% of the total market cap. The US is tightening the screws on China concept stocks. That means more such stocks may want to come back, and that would mean opportunities for Hong Kong. Investment banks estimated that 27 ADRs may qualify for listing in Hong Kong. Their market cap is also at 1.4 trillion Hong Kong dollars. And then their corporations may also adopt intermediary holding companies in their structure. So they transfer their stocks in their own domicile, no stock, no stamp duty applies. So our regime should also target those companies. For this unlisted companies, let's waive the stamp duty on their stock transfers that would otherwise apply under our laws. That's how we can strengthen the incentive for those companies to come here. Now, on the eligibility of mainland companies, here are my thoughts. The bill lays down 2 criteria. 1, the law of the place of domicile does not ban it, and 2, the AOA of the company does not prohibit it. And there should be a mechanism in the place of domicile to deregister the company. No such restriction is in place in the mainland's laws. And our company's law also says that when a company is disbanded or goes into bankruptcy, that company can apply for deregistration with the authorities. There is a way for those mainland companies. They can apply for redomiciliation on other grounds under our country's companies laws. So for us, we should be telling the mainland authorities about our redomiciliation regime. Mainland government may also design their own deregistration regimes to tie in with our redomiciliation regime. My second point is a balance between development and security. The two matters go hand in hand. The redomiciliation regime may bring risks, including national security risks. That's why the bill comes with provisions to deal with that. Section 820C3. That's a provision that says when the registrar is looking at an application, the registrar has to put national security risks first. Some actions that appear to be corporate actions may also come with latent national security risks, and we should take them seriously. I welcome the government's adoption of our proposal by proposing amendments that when the registrar thinks an impending redomiciliation may be used for unlawful purposes or contrary to public interest, and that would also include endangering national security, the registrar must refuse the application. I want to draw everyone's attention to the fact that Hong Kong is different from Singapore. Singapore asks for 10 million Singaporean dollars in assets or 10 million Singaporean dollars in revenue or hiring 50 workers or more. In Singapore, such a requirement applies, whereas we don't have that requirement. The administration said the point is to get more companies to come here, though we will look at the integrity and other aspects of companies trying to come here. I support that. Now, the other point has to do with the transitional period. A company receiving the redomiciliation certificate has 120 days to deregister in their original domicile. Stakeholders argued the original 60-day limit may not be enough for the company to go through the registration in their own original domicile. So now it's 120 days instead in Australia and New Zealand and other jurisdictions with offshore companies. Those places don't set a time limit on the registration. In Singapore, the limit is 60 days. Legal procedures and uncertainty are involved in the transitional period. So I urge the government to take appropriate measures. So we should be asking those redomiciled companies to confirm that they have already put out a notice in their original domicile or take out newspaper ads or announce the redomiciliation online so that their creditors know what has gone on and that will lower the legal risks. Now, for insurance and banking, these two industries are subject to rigorous legal scrutiny here, so higher requirements apply. That's why there are changes to the subsidiary legislation for non-locally incorporated insurers and authorized institutions. Those businesses have to first talk to the insurance authority or the HKMA, as the case may be, to make sure they qualify for the redomiciliation requirements. So I hope the insurance authority and the HKMA to pull their weight on this. This will mean safeguards, because the banking sector and the insurance sector will be able to operate in a stable environment. And we can also make sure that those companies trying to come here know what to expect. So as the way forward, let's do more on publicity. Get more companies to come here so that we can act as this gatekeeper. We can get more companies to come here. I so submit.
Dr. So Chao-Wing, thank you, Deputy President. The bill seeks to introduce a redomiciliation regime into Hong Kong so that a straightforward avenue can be provided to non-Hong Kong incorporated companies to redomicile to Hong Kong. At the same time, they can preserve their legal identities, assets, etc., and ensure business continuity. It also helps save costs and time in terms of the restructuring or winding up that would otherwise be required. The new regime seeks to attract capital and enhance our international competitiveness. This also allows the government to create a favorable business environment and promote diversified economic development in Hong Kong. In recent years, there have been changes in the international taxation matters. Because of regulatory changes, offshore companies in certain jurisdictions such as Cayman Islands, BVIs, etc., have seen a surge in compliance costs. Multinational corporations, therefore, are looking for alternatives, and Hong Kong's new redomiciliation will bring a number of benefits. It will attract overseas companies to set up presence in Hong Kong. It will also bring impetus to our capital markets and promote professional services. According to the accounting profession, a large number of overseas companies with substantial business in Hong Kong will consider redomiciling into Hong Kong. This will bring impetus to the local economy. I think the regime is well designed. However, there are complicated matters relating to taxation, supervision, and financing in redomiciliation. And after introducing this regime into Hong Kong, the government should roll out enhancement measures in a timely manner. Because Hong Kong is not the only place with a redomiciliation regime. Other places, such as Singapore, has already implemented this regime for some time. We must improve our business environment on the whole so as to provide good fundamentals for overseas companies to come to Hong Kong. My suggestions are as follows. We should enhance collaboration in the Greater Bay Area. Many non-Hong Kong companies regard the Greater Bay Area as having unique advantages. It's also a hub for connecting to the mainland. In light of these circumstances, our government should strive for central authorities' support. Business facilitation measures should be rolled out in Hong Kong and in the Greater Bay Area so that offshore companies can enjoy seamless connection in the Greater Bay Area to the vast market. The second suggestion is to promote headquarters economy. The redomiciliation regime will provide an incentive for non-Hong Kong corporations to set up headquarters into Hong Kong, in particular in the new growth areas such as innovation, technology, green finance, family offices. Facilitation should also be provided to multinational insurance companies, financial institutions specialized in wealth management, etc. This will create a cluster effect for headquarters to be set up in Hong Kong. The government should enhance the supporting measures for building a headquarters economy. My third suggestion is this. The government should review all the rules and regulations and remove red tape and hurdles for the business sector. There is a prevailing view in the business sector that the compliance regulations in Hong Kong are too harsh and we are lagging behind our competitors. We should conduct a timely review. The last suggestion is this. A one-stop service platform should be set up. The roles of the TDC, Invest Hong Kong, Companies Registry, and the IRD should be enhanced. There should be more collaboration and coordination. Through this platform, we can provide guidance and also compliance toolkits. We can also digitalize the services and streamline the workflow to enhance efficiency. My last suggestion is that the government should be the gatekeeper. The government should make sure that corporations do not come to Hong Kong for the purpose of tax evasion. The system should not be abused. We need to safeguard our reputation as the international financial center. I support the bill. Dr. Sunny Tan. Thank you, Deputy President. I speak in support of the Companies Amendment No. 2 Bill 2024. With passage of the bill, non-Hong Kong corporations will be able to preserve their legal identities in redomiciling in Hong Kong so as to ensure business continuation. They'll be able to save costs without having to go through cumbersome legal procedures. We are the most internationalized city in Asia. We have a century's record of being an international trading and financial hub. And under one country, two systems, we enjoy some unique advantages in terms of professional services, trade, financial services, transport and logistics. I believe the amendment bill will provide us with a further edge to consolidate our status as an international financial and trade center. Now, this bill provides competitiveness. For example, after getting a certificate of redomiciliation, the bill requires the company to be deregistered in the original domicile within 120 days, comparing to the deregistration period of Singapore, which is we provide a longer period. This gives us flexibility, and this also helps us attract enterprises at different stages of growth. In the future, in order to attract more non-Hong Kong corporations to redomicile and set up presence in Hong Kong, the administration should continue to improve the legislation by cutting red tape and removing hurdles, such as what the administration has done on this occasion, so as to keep abreast with the times and enhance efficiency. More facilitation should be provided to help enterprises cut costs. We should also improve our status so that we are the #1 choice in terms of supply chain management, financing, doing business, testing, certification, etc., so that we can enhance our competitiveness and create new growth points.
Mr. Chen Pui-Leung. Thank you, Deputy President. In the past, Hong Kong did not have a statutory regime to recognize companies to redomicile in Hong Kong, but there is a growing need for domiciliation. To combat base erosion risk and profit transferring shifts, there are some 140 jurisdictions that have indicated acceptance to the BEPS 2.0 proposals. Now, it results in increasing compliance costs for many companies. Now, I support this proposed redomiciliation regime, in particular for companies with a major business focus in the Asian region. Now, in the past, for companies seeking to redomicile in Hong Kong, they needed to wind up their companies and establish a new company in Hong Kong, or apply for a court-approved arrangement scheme to establish a wholly owned subsidiary in Hong Kong. It involves complicated procedures with high cost. This amendment to the company's ordinance will introduce a simpler system with lower administrative and legal costs and shorten the time period required for a wind-up procedure. The new redomiciliation regime will be beneficial to non-Hong Kong incorporated companies and non-Hong Kong companies which already have businesses in Hong Kong. They can maintain their legal identity and carry on with their business. Moreover, they can extend the coverage of their geographical coverage of their business and align it with their place of origin. They can also enjoy Hong Kong's premium professional services and a low tax regime. More importantly, it will help us develop the headquarters economy and introduce more quality enterprises and generates more demand for professional services and provide jobs. The move will also bolster our position as an international trade and financial center, and also a free and open economy. Now, the trade has been urging for the government to introduce this regime. The top 10 insurers in Hong Kong, many of them are incorporated elsewhere, accounting for 80 to 90% of our local insurance business. Many of them have indicated interest in a redomiciliation regime. Now, for non-Hong Kong incorporated insurers, they need to engage in compliance work in both places. Under the new redomiciliation regime, they only need to declare these information in Hong Kong, lowering the administrative cost. Now, the amendments have met the aspiration of insurers for moving to Hong Kong. For example, among the 12 insurers registered in Bermuda, many of them have indicated an interest to move their domicile to Hong Kong. And also there are some 14,000 non-Hong Kong incorporated companies with business addresses in Hong Kong. Half of them are registered in the British Virgin Islands. Now, these companies with a stronger connection with Hong Kong are likely to re-domicile in Hong Kong. Now, with seamless transfer of the headquarters into Hong Kong, it will enhance our position as an international financial center. It is also a vote of confidence in Hong Kong. After the passage of the bill, I urge the government to step up promotion by combining the efforts of Invest Hong Kong, the TDC, as well as ETOs and the Oasis. In particular, to body corporates which have businesses in Hong Kong. And also, suitable assistance should be given to re-domiciled companies. Information and actual assistance should be given to them to bolster our position as an international financial center. I also submit and support the Companies Amendment No. 2 Bill 2024. Mr. Chen Kin-po, Deputy President, I speak in support of the bill on behalf of the insurance sector. Many years ago, because of tax and regulatory reasons, many insurers have chosen to incorporate in tax havens overseas. Now, these tax havens have seen their compliance cost greatly increased, weakening their competitiveness. As a result, many insurers are planning to re-domicile their companies to Hong Kong. Under the existing regime, non-Hong Kong incorporated companies need to wind up their company in their original place and establish a new company or apply for a court-sanctioned regime to re-domicile. The procedure is exceedingly complicated and costly. Now, as per the request of the insurance sector, the government is now establishing the re-domiciliation regime, greatly lowering the cost for re-domiciliation by body corporate. Legal entity can be retained. The process is greatly simplified, and the time needed is much shorter as well. Now, there are 5 to 6 insurers who already plan to re-domicile to Hong Kong after the passage of the bill. But there is a requirement to deregister the companies in the place of operation within 120 days after re-domiciliation. And there are also changes and also the changes must be reported to the banking and insurance authorities. Now, there is a requirement for the insurers to obtain a letter of no objection from the insurance authority to re-domicile in Hong Kong. In other words, it means that the overseas insurers will be subject to the same regulatory rules as Hong Kong incorporated companies. It will enhance their competitiveness. And also, the time limit for the registration has been extended from 60 days to 120 days. It is a balance between efficiency and convenience for the trade. It highlights the positive interaction between the trade and the government. Hong Kong has a world-class professional service network. The core business, Hong Kong is the hub of the Asian insurance business. Now, after the passage of the bill, more insurers will make use of the simplified regime to re-domicile in Hong Kong. It poses new opportunities for the insurance sector. Besides enhancing our international competitiveness, it will also bring about job opportunities in the auditing and accounting and financial services business. It will inject new drive into our economic developments and bolster our position as an international insurance center. Now, the trade hopes that the government will continue to enhance the regime and also conduct a global publicity to achieve a win-win situation. Thank you.
Ms. Nixie Lam.
To express my support for the Companies Amendment No. 2 Bill 2024. This amendment introduced a corporate domiciliation mechanism, enabling companies incorporated outside of Hong Kong to re-domicile their operations to our city while retaining their legal entity status. This avoids the needs for complex procedures such as liquidation or court-sanctioned arrangement. While this may appear to be a technical adjustment, it demonstrates Hong Kong's proactive response to shift into the international business environment and strengthened our appeal as a destination for global enterprises. The demand for such a mechanism has been clear through discussion with a lot of the industry peers. I've learned that many businesses keen to establish a presence here previously faced a cumbersome, costly, and time-consuming procedures. Companies are required to either wind up their operations or navigate protracted legal procedures. This bill will create a direct registration pathway for these companies, allowing them to transition smoothly to Hong Kong without sacrificing their existing legal standings or restarting operations. That said, while facilitating ease of businesses, we must uphold the fundamental safeguards. I fully endorse the government's prudent approach to applications involving national security considerations. The bill rightly stipulates that registrars must refuse an application if there are reasonable groundings to believe a company could endanger national security or public interests. This ensures that we maintain robust safeguards even as we attract investment. However, establishing principles is only the first step. Industry stakeholders have raised some concerns that overly burdensome procedures or excessive disclosing requirements could deter potential applicants. So I urge the government to draw references from other jurisdictions nearby, so other countries, to streamline their documentation requirements and minimizing unnecessary disclosures while upholding the compliance requirement. Promoting digital submission procedures would also enhance efficiencies and reduce administrative burdens on businesses. Furthermore, we must focus on targeted outreach. Over 1,500 non-Hong Kong companies are already registered here, many with established operations, teams, and resources. These entities represent the most likely candidates that will do the procedure, while the government has indicated that the ETOs, Invest Hong Kong, and all the other officers for attracting a strategic enterprise will promote the mechanism, supplemented by the redomicilizations guidelines. I would believe proactive engagement is very crucial in this procedure, so direct dialogues to understanding specific corporates concerned would also enable more tailored support for them. It is worthwhile to noting that the corporate redomicilizations often involves more than nominal relocations. A lot of the companies may bring accountings, company secretaries, secretariats, compliance teams and stuff, and also their senior management roles to Hong Kong. So these high-value positions will create employment opportunities for local Hong Kong markets and ensure that to enhance the industrial chain density and also deliver tangible benefits for local professionals and sectors. I think this bill is not merely about boosting registration fee revenues only. I think it's a long-term economic values lines in reinforcing Hong Kong's role as a super connector and also a deeper international investment center. With an effective implementation of clear communication and seamless procedure, I think I'm very confident that this mechanism will attract a lot of more high-quality enterprise to come in Hong Kong and inject a fresh momentum into our economy. Thank you, Madam Chairman. I support this bill and I rest my case.
Mr. Ma Fung Kwok. Madam Deputy, I support the company's amendment number 2, Bill 2024. This is about a company redomiciliation regime. Different places are trying to make themselves more competitive with measures involving their market access thresholds and tax arrangements. Hong Kong is legislating for this 15% global minimum corporate tax rate. In this context, I support this bill. There are companies seeking to move their domicile here. We're trying to come up with a straightforward redomiciliation regime, and this bill is an effective measure to that end. This will strengthen our role. as a hub for business and professional services in Asia Pacific. This bill will also do great things for our great professional services sector. We are proposing this inward redomiciliation regime because some major insurers are trying to look elsewhere. They're trying to move their domicile from places like Bermuda, the British Virgin Islands, and Cayman Islands to Hong Kong. We already have our company's ordinance. We have a great regulatory regime for financial services, etc. With this redomiciliation regime, those businesses want to come here, but we have to remain a free port and a separate customs territory. We still need our simple and low tax regime, an independent judiciary system, and also this common law system. That way, international businesses will be comfortable about moving their domicile here and developing in Hong Kong. When those businesses operate in Hong Kong, they will hire local workers, they will pay taxes. Now, redomiciliation may not bring dramatic benefits on its face, but Hong Kong is a super connector. Let's look at other common law jurisdictions. Think Singapore, New Zealand, and Canada. Those places have their own redomiciliation regimes. So, to stay competitive, we have to act. Different countries have also toughened action against money laundering. The European Union, for example, has put businesses in the British Virgin Islands on the list of non-cooperative jurisdictions. Actions like that will get more companies to move their operation from tax havens to other jurisdictions. When more non-local companies move their domicile here, there will be a growing need for professionals such as accountants and company secretaries, and that will be good for Hong Kong as a financial center. That will also mean more investment, and in turn that will mean more jobs. The government has responded swiftly by proposing amendments to the company's ordinance, and that change is in the form of this bill. I commend the government's work, and let's also closely watch changes in the global economic landscape, and let's also review Hong Kong's own situation so that we continue to enhance systems. Let's give support to businesses. Let's give them the support they need and safeguard our role as a financial center in Asia Pacific. Let's contribute to our country so that we stay this super connector. As Seoul submit, I support the company's amendment number 2 Bill 2024.
Mr. Adrian Ho. Thank you, Deputy President. I speak in support of the company's amendment Bill number 2 Bill 2024. As of the end of last year, the number of companies incorporated in Hong Kong exceeded 1.4 million. For non-Hong Kong incorporated companies, we recorded 15,000. So both are record highs. In light of COVID pandemic and geopolitics, there are a lot of global uncertainties, and still we managed to register more companies in Hong Kong. That shows that Hong Kong is a well-established and attractive international financial center. Now, the global economic power is shifting to the east from the west. Together with the looming trade war, there have been a rapid drain of capital from traditional economies to other robust markets such as Hong Kong. Now, we enjoy the unique advantage of having the motherland's support and connected to the world, so we are an important capital market. In the first quarter, GDP in Hong Kong grew by 3.1%. IPO markets also performed very well. There has been a net inflow of capital. It shows that international investors are ever more confident in Hong Kong's business environment. At this juncture, we've introduced the redomiciliation regime. This is a pivotal measure to enhance Hong Kong's competitiveness and attract capital to come in. offshore companies or non-Hong Kong incorporated companies will be able to redomicile in Hong Kong at a much lower cost, and they can then tap the Greater Bay Area markets and expand the business in the APAC region. According to the speech delivered by the Secretary at the panel, without redomiciliation regime, a company wishing to redomicile to Hong Kong will need to first go through a winding up procedure or can only do so under the court-approved scheme of arrangement. These are complicated and cumbersome legal proceedings which entail a very high cost. It also doesn't provide business continuation or preservation of the legal status or assets of the company. So this bill serves as removal of the hurdles so that companies intended to redomicile to Hong Kong will enjoy business continuity. It will also be allowed to preserve the legal obligations, assets, legal entities, etc. Starting from the date of redomiciliation, this entity will be regarded as a tax resident in Hong Kong. It will also enjoy the preferential tax treatments under the CDTAs that Hong Kong have signed with over 40 jurisdictions. So the redomiciliation regime will help make Hong Kong an important hub. It's also a great incentive for companies to tap the APAC market here. We also have very mature professional services such as legal and accounting professions. They can also give play to the advantage of Hong Kong as a free capital market. In recent years, we have corporations incorporated in BVIs, Bermuda, etc. They have substantial economic activities in Hong Kong, especially insurance companies. They have expressly shown interest in redomiciliating in Hong Kong. Now we have a robust redomiciliation regime that can provide facilitation that we will be catching up with Singapore and Australia. We'll be able to attract these multinational corporations to set up regional headquarters here and enhance our competitiveness. Now, this bill has also taken on board the views of different stakeholders. Some members in the deliberations referred to national security risks. The administration considered these views and will be introducing amendments. There will be proper gatekeeping in the application process. There will also be effective measures to guard against national security risks. The company registrar will act as the gatekeeper. If in the opinion of the registrar, the company intended to be redomiciled to Hong Kong has done so for an unlawful purpose or for a purpose that may endanger national security, the original bill provides that the registrar may refuse the application so as to deter any acts that may go contrary to the public interest or endanger national security. In the next few years, I hope that other measures will be put in place to further consolidate Hong Kong's status as an international trade and financial center. We should create a more favorable business environment. And I think this bill, which introduces a company redomiciliation regime, is a timely measure. We should grasp the opportunity to provide more facilitation measures for non-Hong Kong corporations to redomicile to Hong Kong. Especially, we have some companies that have already set up a presence in Hong Kong. The redomiciliation regime can help them lower costs of compliance and further consolidate Hong Kong into a hub for multinational corporations. The Invest Hong Kong, ETOs, Hong Kong Exchange, and chambers of commerce outside of Hong Kong should enhance collaboration. We should be proactive in introducing the new regime to overseas companies. We should tell them about our rule of law, professional services, and other advantages, and our role in the Greater Bay Area. I support the bill. Mr. Bill Tang. Thank you, Deputy President. I speak in support of the Companies Amendment No. 2 Bill 2024. This bill is about the redomiciliation regime. In the past few years, Hong Kong faced internal and external headwinds. We continued to improve local business environment. Now, the Hong Kong SL government set up the Talent Engage as well as Oasis to take forward strategic measures such as to troll for talents and attract enterprises. This amendment bill will further remove policy red tape for enterprises. Through the redomiciliation regime, we can further boost the development of Hong Kong as a headquarters economy so as to attract more international talents, capital and enterprises to come to Hong Kong. Under the existing legislation, non-Hong Kong incorporated companies must first go through the winding up process or do so under the court-approved scheme of arrangements before removing their domicile to Hong Kong. They need to set up a new company. This process is cumbersome. It also is costly. There are also uncertainties involved. Many such companies are therefore deterred. The redomiciliation regime will allow a direct redomiciliation of these non-Hong Kong corporations to Hong Kong without having to be wound up first and without having to go through cumbersome legal procedures. The regime provides certainty. It also helps reduce costs and risks. The redomiciliation arrangement will not affect the existing assets, obligations, liabilities, and legal status of the companies. So the redomiciliation regime can ensure business transition to Hong Kong without any interruption to their business. Like Mr. Hui, Secretary, said, this is a timely introduction in response to global requests. We have had regard to the global landscape. We want to make Hong Kong a safer and freer and more open place for business. There should be policy certainty. Apart from attracting overseas corporations to come to Hong Kong, we should also be vigilant against the potential national security risks. That is why, in the course of deliberating on the bill, the members have scrutinized certain wordings. For example, there is a proposed new section 820C(3), and there is an amendment will be proposed to change the word from may to must. That is, if in the opinion of the registrar, the company involved is likely to, or if the company is likely to be used for an unlawful purpose, including for the purpose of endangering national security, then the registrar is obliged to refuse its application to make sure that the overall interests of our country are safeguarded. We should make sure that this regime is properly used. That means the government should proactively reach out to overseas companies through the ETO network. Hong Kong is now at a critical stage of economic development. This redomiciliation regime carries a significant strategic meaning. It also brings economic benefits. It helps consolidate Hong Kong's status as an international financial center. It also brings business opportunities for various professions and professional services in Hong Kong. These companies redomiciling to Hong Kong will bring quality jobs and professional service opportunities. I support this bill and the amendment.
Does any other member wish to speak? If not, I now call upon the Secretary for Financial Services and the Treasury to reply. Then the debate will come to a close. Secretary. Deputy President, since the introduction of the Companies Amendment No. 2 Bill 2024 into the Legislature, 4 meetings have been held by the Bills Committee to study the policy objectives of the bill and scrutinize the clauses in detail. I give my heartfelt thanks to Mr. Edmund Wong, the chairman of the Bills Committee, under whose leadership the scrutiny work was completed smoothly. I also thank the participation and efforts made by the Secretariat and the legal advisors as the members, and also all the stakeholder bodies and institutions which have given their invaluable views to the Bills Committee. I also thank all the members who have spoken just now. Your suggestions have made significant contribution to our work. Attracting foreign enterprises, investment and talents is a key direction for Hong Kong's development. In light of international tax and regulatory developments in recent years, including the implementation of BEPS 2.0, which impose a 15% global minimum tax on in-scope multinational corporations, as well as the fact that some jurisdictions have imposed economic substance requirements on their incorporation. It has increased the compliance costs borne by offshore companies and creating a demand for redomiciliation. At present, before redomiciliation, a company must wind up its operation and establish a new company in Hong Kong or change the company into a wholly owned subsidiary by way of a court-approved scheme of arrangement. The compliance cost is huge, and also the new company cannot retain the original legal identities, corporate history, and the IP as well as other assets it holds. Now, since November 2021, we have introduced the redomiciliation regime for open-ended fund companies or limited partnership funds. It is an opportune time to introduce a redomiciliation regime for companies in general so that redomiciled companies can retain their legal entity after redomiciliation and also continue with their operations without paying a huge compliance cost. Now, this will benefit Hong Kong in that we can facilitate the use of our robust professional services as well as our robust corporate governance system and tax regime, and also bring greater demand for our professional services, including auditing and accounting. Some enterprises will also bring their operations to Hong Kong, bring about more job opportunities. Now, the bill amends the company's ordinance to introduce a company redomiciliation regime and specify the application eligibility, necessary documents and procedures for redomiciliation, as well as provide for the legal effects of redomiciliation. During the scrutiny process, members have had an in-depth discussion and given invaluable views on the risk management of the redomiciliation regime as well as the overall drafting of the bill. Now, I will highlight several points. 1. Managing a national security risk. Safeguarding national security is our overarching duty. In formulating the company redomiciliation system, sufficient regard has been given to potential national security risk. Suitable safeguards are put in place at the application phase and after redomiciliation. The bill provides for a mechanism to refuse a redomiciliation application on national security grounds and to deregister a redomiciled company. In response to members' views, we will move an amendment to more comprehensively reflect our policy considerations, which are strict gatekeeping on applications to safeguard national security, ensuring the legality of redomiciled companies and upholding public interest. The Bills Committee supports the amendments. Later on, at the committee stage, I will explain the amendments. Second, the overall drafting approach of the bill. Besides introducing new provisions in relation to redomiciliation regime to the company's ordinance, there are other amendments to the existing provisions and subsidiary legislation of the company's ordinance and also 39 pieces of enactments. For clarification of the applicability on redomiciled companies. Now, we have noted that members are concerned about the sheer number of amendments and their suggestion to replace them with generalized provisions. An important principle in law drafting is that enactments must be as clear and as well defined as possible. The drafting approach must suit the policy intent behind each amendment and the individual circumstances of the existing provisions so as to strike a balance between clarity and conciseness. That's why certain amendments, in particular provisions relating to offences and penalties, must be drafted as detailed as possible to avoid ambiguity, unclear responsibility, leading to difficulty in prosecution. We thank members for their suggestions on making some provisions more concise. Having considered the POJ, we will propose amendments to simplify the provisions without affecting the legal effect. Also, the Bills Committee and some stakeholders have made pragmatic suggestions on the eligibility criteria for application as well as the amendments to other enactments. In response to these suggestions, we will move amendments to more accurately reflect our policy intent. At the whole committee stage, I will explain the amendments in detail. Deputy President, in this legislative exercise, we have conducted an extensive public consultation exercise and have maintained close communication with stakeholders, including Chamber of Commerce, professional bodies, consultation bodies, as well as individual companies. We understand that some companies are already actively considering to redomicile in Hong Kong under the new mechanism. The bill's provisions and our amendments have responded to the concerns on the redomiciliation mechanism by stakeholders. I implore members to support the passage of the bill and also the CSA amendments so that we can implement the regime to respond to market's demand. This is a great opportunity for us to attract more foreign enterprises to come to Hong Kong and boost our overall development. After the passage of the bill, the company redomiciliation regime will take effect on the day of Gazettal. Subsequently, together with the Invest Hong Kong, the Hong Kong Exchanges and Clearing Limited, and our ETOs, we will launch a publicity campaign to actively reach out to major listed companies in Hong Kong, incorporated elsewhere, and other foreign enterprises to redomicile in Hong Kong. I so submit.
I now put the question to you that the company's amendment number 2, Bill 2024, be read the second time. Would those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Company's amendment number 2, Bill 2024. This council now becomes Committee of the Whole Council to consider the company's amendment number 2, Bill